Hi, everyone. Welcome to the Duplication of Benefits course that we are presenting today called The Tough Cases. We are a team of 3 attorneys who work in HUD's Office of General Counsel, and while we are attorneys who happen to be subject matter experts on the duplication of benefits, we are actually here to advise our client, the program office, the Disaster Recovery and Special Issues Division of HUD's Community Planning and Development Office of Block Grant Assistance. And so we advise them, and we do not advise grantees directly, and nothing we say here today is legal advice. So always consult with your own attorneys, but we are here primarily in our role as subject matter experts today. And to get started and kick things off, we're just going to introduce ourselves. My name, as I said, is Carrie Whitehead. I'm a managing attorney in HUD's Office of General Counsel. I work in our Community Development Division, and I've been program counsel to Community Development Block Grant Disaster Recovery Grants since 2009 when I started at HUD. I have a team that I work with. It's a fantastic team to work on. So I will pass it over to the other team members to introduce themselves. Makani, take it away.
Thanks, Carrie. Good afternoon, everyone. Thanks for joining us for this presentation. I'm Makani Drummond. I'm another attorney in HUD's Office of General Counsel, Community Development Division, and I've been program counsel for Community Development Block Grant Disaster Recovery Grants for about 7 years, since about 2015. Dory, I'll hand it off to you.
Good afternoon, everyone. My name is Dory Kojima. I'm attorney advisor with HUD. I work with Makani and Carrie on CDBG-DR. I've actually been program counsel since 2018 and have really enjoyed working on this program and working with Makani and Carrie. So I just want to welcome everyone to our session on duplication of benefits, the tough cases. I'm going to start off by going into the objectives of this training session. I just want to make everyone aware that this is an advanced session. We're going to cover concepts that are a little bit more complicated. If you do want to kind of have a refresher or look back on some more basic concepts about DoB, you can look at the 2020 training session that was delivered in September of a similar virtual CDBG-DR training session that is available online, and I believe we're going to post it in the chat. So the objectives of this session is that grantees will understand what DoB requirements apply to disaster recovery, mitigation, and NDR grants. Grantees will be able to complete a basic DoB calculation. Grantees will understand how to approach more complicated DoB problems, including the treatment of loans, and using DoB when CDBG is used as a match for other assistance. And finally, grantees will understand the consequences of failure to prevent or collect duplicative financial assistance. Our agenda for today is that we're going to start off with just a basic overview of duplication of benefit concepts. Then we will go over a framework for a DoB calculation. And then we'll move into the complex examples, in particular, the treatment of loans in a DoB analysis. CDBG-DR funds used as match. We'll go over other case studies that are more complicated, and we'll finish off with reviewing resources and then leave time for questions. So just to start off with the concept overview about duplication of benefits, we'll start off with the definition of what is a DoB. A DoB is a person that includes and this means an individual, household, business, government, or other entity that receives financial assistance from multiple sources, and that assistance is for the same purpose, and the total assistance is greater than the total need for that type of assistance. So some of these concepts, financial assistance, purpose, will go into more detail when Makani reviews the framework for the DoB analysis. but this is just to provide you with this basic definition of DoB. What I did want to highlight is that generally you should think about it as the amount of the DoB is the amount of assistance in excess of need. And also just want to highlight that even though the definition says person, it applies to individuals. It applies to businesses, governments, and other entities, as well as individuals. And really, the DoB concern, the requirements all arise from this basic idea that we want to be responsible users of taxpayer dollars. The DoB grant funds are a limited resource. Congress provides them in the supplemental appropriations is based off allocates them on based off greatest need. And so we just want to be aware and make sure that if there's already sources covering a disaster need, that we don't want to be duplicating and providing more assistance than is necessary. So we're going to start off by just going over the sources of the DoB requirements. These include the Section 312 of the Robert T. Stafford Disaster Relief and Emergency Assistance Act, or the Stafford Act, as we're going to call it in this presentation. The acts that are the appropriation acts for the CDBG disaster funds, as well as HUD's Federal Register notices that sets forth the requirements on the use of CDBG-DR funds. The OMB Cost Principles contained at 2 CFR 200 subpart E, and HUD imposes these requirements also in the grant agreements, as well as grantees are required to put them in the subrecipient agreements. So we're going to go over these sources individually right now. So we're going to start off with the Stafford Act. The Stafford Act is the primary legal authority that establishes requirements for the federal government to provide disaster and emergency assistance, and this includes the DoB requirement. Specifically, Section 312 directs federal agencies to provide assistance to assure that people, businesses, and other entities do not receive financial assistance for a loss that is already covered by another source. So based on that directive in Section 312, HUD imposes DRB requirements on its grantees and its use of funds. In addition, the Stafford Act, Section 312C, has an additional DoB liability provision, which makes recipients of federal disaster assistance liable for repayment of the amount that is equal to the DoB. And while HUD enforces against the grantee, there may still be individual liability for persons who receives the DoB. The Stafford Act also requires that an agency which provided the duplicative assistance recaptures that DoB amount from the recipient. And I just wanted to highlight that the Stafford Act requires that the person is liable to the extent that such assistance duplicates benefits that are available to the person for the same purpose from another source. And we're going to go over what this means to be available. That term available is used in several different contexts in relation to DoB. But I just wanted to highlight that this is what the term available is also included in Section 312 of the Stafford Act. So another place where you find the DoB requirements is in the OMB Cost Principles. The cost principles at 2 CFR Part 200, subpart E, are applicable to CDBG disaster recovery grantees and their subrecipients. It requires that costs paid for with CDBG disaster funds are necessary and reasonable. This aligns with the Stafford Act requirements for DoB. And what does it mean to be necessary and reasonable? At 2 CFR 200-404, there are factors that the grantee must consider when determining whether a cost is necessary and reasonable. Basically, when we think of necessary, in the DoB analysis, there's a calculation for unmet need. And we think about whether it meets the programmatic requirements, whether it's for an eligible activity, is it for a permissible recovery purpose? In regards to reasonable, we apply the prudent person standard. about whether a cost would be reasonable in its nature and amount if it does not exceed that which would be incurred by a prudent person under the circumstances prevailing at the time the decision was made to incur the cost. So in the acts that appropriate the funds for disaster recovery for CDBG-DR, there's also DoB requirements that are specific to each appropriation act. They're generally, this language is generally the same, and these statutory requirements include the DoB requirements, like the one that's included in this slide. In compliance with each appropriation act, HUD allocates and publishes the grant requirements in the Federal Register notices. The language here that as a condition of making any grants, the Secretary shall certify in advance that such grantee has established adequate procedures to prevent any DoB as defined by the Stafford Act, means that as a condition of making a grant, HUD must certify that the grantee has adequate procedures to prevent a DoB. And this is implemented in that grantees, in order to meet this requirement, must provide HUD with its DoB policies for review and certification prior to the signing of the grant agreement. So to comply with Section 312, each grantee must ensure that each activity provides assistance to a person or entity only to the extent that the person or entity has a disaster recovery need that has not been fully met. And this language is here to demonstrate that this DoB requirement is put on each grantee to enforce. HUD has published the DoB requirements in the following notices: the 2011 DoB notice, the June 2019 Duplication of Benefits notice, as well as there's a Duplication of Benefits implementation notice that accompanied the June 2019. And basically that HUD requires that the grantee has adequate policies and procedures that incorporate specific certain steps for a DoB analysis and checking for whether a DoB will occur prior to committing an award or providing assistance. So I wanted to highlight and compare and just demonstrate and show that there between the two DoB notices in 2011 and 2019. The 2011 notice applied to any new activity that included was included in a new or amended action plan after November 16th, 2011, and it continues to apply to activities for disasters declared before 2015. The 2019 DoB notice became effective on June 25th, 2019. It was published June 20th, but its effective date was June 25th. It applies to the grantees receiving funds for 2015 and 2021 disasters. And in regards, and specifically, I just wanted to highlight in the treatment of loans, a grantee's choices in the treatment of loans affect which notice applies to the activities that predate the 2019 DoB notice. For 2015 and 2017 disasters, the 2011 notice shall continue to apply to activities that were included in an action plan before June 25th, 2019. Unless in regards to the treatment of loans, the grantee amends their action plans or policies and procedures to change the treatment of loans in accordance with the 2019 DoB notice. For 2015 and 2019 disasters, the 2019 DoB notice supersedes the 2011 notice for any new activity included in an action plan or amendment after June 25th, on or after June 25th, 2019. And for existing programs and activities for these 2015 to 2019 disasters, in regards to the treatment of loans, to the extent that the grantee amends its action plans or its policies and procedures to change the treatment of loans in accordance with the 2019 DoB notice, those 2019 DoB notice requirements apply. So it's limited to the extent that the grantee amends its action plan or amendment to apply the 2019 DoB notice requirements to the treatment of loans. So another source of the DoB requirements are the grant agreement, as well as the subrecipient agreements. HUD generally puts in its grant agreements that the requirements of the Appropriations Act and Title I of the Housing and Community Development Act of 1974 and applicable implementing regulations at 24 CFR Part 570 as now in effect and as may be amended from time to time and is modified by waivers, alternative requirements, and other requirements described in the agreement and published in the Federal Register notices are hereby incorporated to and made a part of this agreement. So just wanted to highlight that, that encompasses the DoB requirements. It also includes language as may be amended. So, HUD may basically change revise those requirements, and grantees are still responsible for complying with those requirements. Grantees are required to pass the requirements on to the subrecipients, not just those that are programmatic, but those that are specific to the DoB requirements. In addition, based on the risk for DoB and assessment of that risk, HUD may impose specific condition on grant funds in accordance with 2 CFR 200-208. And these specific conditions can be maybe documented as an amendment to the grant agreement, included as part of the subrecipient agreement for the use of funds. So I also wanted to go over the DoB versus the order of assistance. They're different concepts, but related. And while the language, to start off with, just to highlight, when we say, you probably have heard the term order of assistance before in working with DoB. And the language may vary among appropriations, but typically provides that CDBG-DR funds may not be used for activities that are reimbursable by or which funds are made available by FEMA or the Army Corps. Again, there's this term available in that language, which generally we say that, it means that if a recipient would have received the funds if acting in a reasonable manner. So we have to think about whether, if those funds are available, if those funds would have been received if the recipient was acting in a reasonable manner. So when we say order of assistance, what we mean by that is that FEMA can impose a regulatory delivery sequence for a particular disaster. FEMA regulations at 44 CFR 206-191 are important in that, in how to think about it is how a DoB is addressed. So the Stafford Act requires that a federal agency that provides duplicative assistance collects the DoB amount, so actually recaptures those funds. The FEMA reg permits FEMA to establish this hierarchy of delivery. So it's based off which agency has the primary responsibility for providing assistance following a disaster. Since CDBG disaster recovery funds are for long-term recovery, it falls lower in the hierarchy of delivery than FEMA or SBA. And so we think we view CDBG-DR as intended to supplement these other forms of assistance and not supplant. So when a DoB occurs, the responsibility of recapturing the duplicative assistance falls on the generally falls on the CDBG-DR grantee or the assistance that was provided last. And since, as I was saying, FEMA or SBA is higher in that hierarchy in the order of assistance, we look at the responsibility for capturing it falls on HUD, which passes that on to the grantee. So now I'm going to turn it over to Makani, who's going to now actually we do have a little bit of time for questions related to this section. So if there's a question specific to this section, I think we have time to take one question.
Sorry, we did not receive any specific to this question, so you are good to transition to Makani.
Okay, thank you.
But it's a great reminder, if you guys have any questions as we're going through the sections of this presentation, to feel free to submit your questions in the Q&A box located at the bottom of your screen.
Great, thanks, Dory and Olivia. So in this segment, I'll cover a framework that lays out the steps to take for identifying and preventing a duplication of benefits. There are 5 steps in the basic DoB calculation framework, and you see them on the slide. These steps start with a very broad focus, and through a process of elimination, they help us arrive at a final award amount of assistance that can be provided to an individual or an entity consistent with the duplication of benefits requirements that Dory covered. DoB requirements are fact-specific, so these are steps that should be used as part of an individualized review of every person, business, household, or entity seeking CDBG-DR assistance before an award is made. On one of the previous slides, Dory mentioned that HUD has published 2 notices on duplication of benefits, one in 2011 and one in 2019. And the concept of a DoB that Dory talked about is the same under both notices. So the steps in this framework that we'll cover are also going to apply regardless of whether we're talking about a CDBG-DR grant that's subject to the 2011 DoB notice or the 2019 DoB notice. There are differences between the 2 notices that will affect the considerations you might take under any of these steps in the framework, but these general steps are going to be the same. The starting point for DoB analysis is the determination of an applicant's total post-disaster need. CDBG-DR funds can only be used to address unmet disaster needs, so identification of the applicant's total need really sets the outer bounds for the assistance that can be provided. A simple example for step 1 is a housing rehabilitation program where you might base the need on the projected cost of repairing an individual's home. This step can be a little bit more complicated if the applicant has received in-kind or non-cash contributions like the donation of goods and services. In-kind contributions aren't financial assistance, so they can't result in a DoB, which you might recall that Dory explained focuses on financial assistance, but they should be considered during this step because goods and services can reduce the applicant's need. The applicant's need is calculated at a point in time, so it's possible that subsequent changes will affect the applicant's need at this first step, and grantees can go through this framework again to reassess the need if that's the case. Next step is to identify all reasonably identifiable assistance available to the applicant and add them up. When we say total assistance available, that includes assistance that has been received in which the applicant has legal control over. That's pretty straightforward, but it wouldn't include a situation where an applicant is legally required to use assistance they've received for some other purpose, like if an applicant has a mortgage that requires them to use home insurance proceeds to pay down their home loan. Since the applicant wouldn't have a right to the funds in that scenario, the applicant's insurance proceeds wouldn't be considered here in a DoB analysis for CDBG-DR that would be provided for housing rehabilitation assistance. Total assistance available also covers assistance that's reasonably anticipated and awarded, but that hasn't been received yet. And so, an example of that might be an applicant who's been awarded FEMA individual assistance, but they just haven't received the funds. Total assistance available also includes assistance that the applicant would have received if they acted in a reasonable manner, meaning if they had taken the same practical steps towards funding recovery as would a disaster survivor faced in the same situation, but not eligible to receive the CDBG-DR assistance. And this means applicants are expected to seek insurance or other assistance that they're legally entitled to under existing policies. Even if an applicant fails to file a claim, if the assistance was available to them had they acted in a reasonable manner, it would be considered under this step. This step also focuses on certain types of assistance. So assistance that it includes are cash awards, insurance proceeds, grants, and subsidized loans. Assistance doesn't include the applicant's personal assets like checking and savings accounts, retirement accounts, or credit cards, or private loans. I'll cover subsidized loans and private loans in a minute and why they're treated differently. This step captures a lot, and not all of what it captures will necessarily be duplicative, but this step is also taking a really broad view to help ensure that grantees are identifying and avoiding any DOBs in the later steps. All right, so step 3. At this point, we've identified the applicant's unmet need as well as the assistance available to them. So this next step is to parse the assistance that we identified to figure out what's duplicative and what isn't. If any of the applicant's available assistance is not duplicative of the CDBG-DR assistance that they're applying for, we can set those amounts aside when sizing the CDBG-DR award. The Stafford Act is really concerned about preventing the duplication of benefits for the same purpose as a loss that's already been covered. So funds for a different purpose and funds for the same purpose, but for a different allowable use, aren't duplicative. If an applicant received insurance proceeds to cover loss of personal property and they're seeking CDBG-DR assistance to rebuild their home, the funds are for a different purpose. So that'd be an example where the applicant's insurance proceeds can be excluded. If an applicant received insurance proceeds to cover damage to their home and they're seeking CDBG-DR assistance to rebuild their home, the funds are for the same purpose, but if the applicant can actually document the specific use of their other assistance and show that it was used for some allowable cost that's different than what the CDBG-DR funds will go towards, that the assistance can be excluded. That would be an example of funds for the same purpose but different allowable use. Purpose is important in this step when considering other assistance available to the applicant, and purpose needs to be based on what the funds were provided for, not what the applicant used them for. So if FEMA provided the applicant with funds to rehabilitate their home, that's the purpose, even if the funds were used for some unrelated expense. So at this point, we've figured out everything we need to know to identify the DoB amount and calculate an award for a particular applicant through a simple equation. We identify the DoB amount first using the first equation on the slide here. We'll take the total assistance available from step 2 and subtract the total amount of non-duplicative assistance from step 3, and that'll tell us the total DoB amount. This represents the amount of other assistance that's available to the applicant that would be duplicated by the CDBG-DR award that they're seeking. Next, we will take this number, the total DoB amount, and use it to calculate the maximum CDBG-DR award available to the applicant. We do that by taking the applicant's total need from step 1 and subtracting the total DoB amount we just calculated. There are a few things that could require an extra step. For example, if the grantee has set a program cap on the amount an applicant can receive, that might reduce the calculated maximum award amount if the maximum award amount exceeds the program cap. Also, it's helpful to keep in mind that the DoB framework is based on an assessment at a specific point in time. So if the applicant's circumstances change in a way that affects their unmet need, the grantee may need to reassess the applicant's circumstances by running through the framework again. So that's the framework, and we can now put it into practice with a short example. So in this example, Mr. Luckless owns an electronic business in a building he owns on Main Street. The building was damaged by a tornado, and we can assume that he's now seeking CDBG-DR assistance to repair his building. The estimated cost to rehabilitate his building is $150,000. So that would be the applicant's need, which we would calculate in step 1. Now we see that Mr. Luckless received $85,000 in total. This would be the step to all of the other available assistance. When we break it down, we see that $65,000 of that $85,000 was from insurance on his building, and $20,000 is from the local EDA, of which $10,000 was for building rehab and $10,000 was for assistance to operate from an interim location during the rehabilitation. This last 10,000, the 10,000 for to operate from an interim location, that would be non-duplicative assistance under step 3 because it's for a different purpose than the CDBG-DR funds that Mr. Luckless is now seeking to repair his building. So if we were to take those numbers and run it through the formula, this is kind of repeating what we just sort of went through, but total need was the 150,000 in step 1 was the 150,000. His estimated cost to rehabilitate his building. We know that the grantee was able to identify that the applicant had 85,000 in other available assistance, and so that's step 2. When we took a look at what the breakdown of what made up that 85,000, we identified 10,000 that was for a different purpose and could be excluded as non-duplicative. That was the 10,000 that Mr. Luckless received to operate from an interim location during his rehab. Step 4 is where we run the formula and we're identifying the total DoB amount. So we were taking the total assistance available in step 2 and subtracting the 10,000 in non-duplicative assistance. So 75,000 of the assistance available to Mr. Luckless is a DoB. Next, we calculate the maximum award that Mr. Luckless can get, and we do that by taking step 1, his total unmet need, and subtracting the other assistance that is a DoB, 75,000. So we were left with 75,000 as the potential maximum CDBG-DR award that Mr. Luckless can receive. In this example, under step 4C, we see that the grantee has a program cap of $50,000, so that reduces the total amount that Mr. Luckless can get from 75,000 down to 50,000. So that's the general framework. In this final segment, we'll cover loans, match, and other case studies to illustrate some different considerations you may need to take as you apply the framework. I'll start us off with the treatment of loans in a DoB analysis. Not all loans are the same, and the type of loan can determine its treatment in a DoB analysis. So what are the different types of loans and how are they treated differently? Private loans are loans that aren't provided by or guaranteed by a governmental entity, where the full amount of the loan must be repaid under typical commercial lending terms. Private loans are never a DoB, and if you think back to step 2 in the framework, where we identified total assistance, you may remember that I had said that we can just ignore private loans. This is because we don't consider private loans with commercial lending terms to be financial assistance, and if you think back to Dory's discussion about the Stafford Act is concerned with preventing the duplication of other financial assistance for the same purpose with CDBG-DR funds. So that's private loans. Subsidized loans are everything else, and this includes loans that don't have typical commercial lending terms, like forgivable loans or disaster loans provided by FEMA or SBA. Subsidized loans might be a DoB. Whether or not depends on whether they've been declined or canceled, or on the particular DoB notice the CDBG-DR grant is subject to. We'll first cover declined and canceled subsidized loans, and then cover the differences based on the DoB notices a little later. One of the circumstances in which subsidized loans aren't a DoB is when they're declined by the applicant. Declined loan amounts are loan amounts that were approved or offered by the lender in response to a loan application, but were turned down by the applicant, meaning the applicant never signed loan documents enabling them to receive the loan proceeds. Thinking back to our DoB framework, declined loan amounts aren't a DoB because they were never received or available to the applicant. Although declined loan amounts aren't a DoB, grantees may need to maintain documentation to show that the subsidized loan amounts truly were declined if the grantee can't verify this based on information they have available. For example, if a grantee has information showing that an applicant received an offer of a subsidized loan, like a disaster loan from FEMA or SBA, but can't determine that the applicant declined the loan, grantee will need to maintain some documentation demonstrating that the loan was in fact declined. In the 2019 DoB notice, one option is for the grantee to obtain a written certification from the applicant confirming they declined the loan. Another circumstance in which subsidized loans aren't a DoB is when subsidized loans are canceled. Canceled loans are loans that were initially accepted, but for a variety of reasons, all or portion of the loan amount was not dispersed and is no longer available to the applicant. The loan cancellation may be due to default of the borrower, agreement by both parties to cancel the undispersed portion of the loan, or expiration of the terms for which the loan was available for disbursement, or really any other reason. Tying this back to the framework, canceled loan amounts are also not a DoB because they're amounts that haven't been received and they're no longer available to the applicant. Grantees need to document that canceled subsidized loans truly are canceled in order to exclude them from a DoB analysis. And this can be documented either through a written communication from the lender confirming that the loan's been canceled and undispersed amounts are no longer available, or through a legal binding agreement between the grantee and the applicant that indicates that the period of availability for the loan has passed and the applicant agrees not to take actions to reinstate the loan or draw any additional undispersed loan amounts. So those are the different types of loans and how they're generally treated in a DoB analysis, but there's sort of another layer of complexity based on the CDBG-DR grant and the DoB notice that applies. Older CDBG-DR grants awarded in response to disasters occurring in 2011 through 2013 are subject to HUD's 2011 DoB notice. And so these grants don't have the benefit of some additional, more recent exceptions to the general rule on how subsidized loans are treated in DoB analysis, which are reflected in the more recent 2019 DoB notice. These 2011 through 2013 disaster grants are also subject to a 2013 memorandum on the treatment of declined SBA loans. And although declined SBA loans aren't a DoB, this 2013 policy requires this group of grantees to develop policies and procedures consistent with the 2013 guidance to analyze an applicant's circumstances, including why the applicant declined an SBA loan offer, and demonstrate that providing CDBG-DR assistance to the applicant is still necessary and reasonable. All costs charged to federal award need to be necessary and reasonable under federal cost principles, as Dory pointed out. This 2013 memorandum just puts some more, is just more prescriptive and requires policies and procedures and certain things to be contained in the applicant's file. All right, so we made it to the sunset slide. You guys can stare off into the digital sunset, comfortable with your understanding of DoB and loans so far, but there's a little more. And things get a little bit more complicated for the more recent group of CDBG-DR grants, which are subject to HUD's 2019 DoB notice. The 2019 DoB notice covers CDBG-DR grants for disasters declared between January 1st, 2015 and December 31st, 2021. The treatment of private loans stays the same. They're still not a DoB, but the 2019 notice adds a few new wrinkles to the treatment of subsidized loans. The first is based on a 2018 law, the Disaster Recovery Reform Act, or DRRA, which adds the section you see on the slide to the Stafford Act. The text, the language of the amendment itself is pretty indecipherable. But fortunately, we have FEMA guidance interpreting it. So this provision, which was added to the Stafford Act, means that a loan is not a prohibited duplication of benefits under the Stafford Act, provided that all federal assistance is used toward a loss suffered as a result of a major disaster or emergency. The law makes this section apply only to major disasters or emergencies declared between 2016 and 2021, and the law also sunsets on October 5th, 2023, meaning this exception is no longer available even for 2016 through 2021 disasters after October 5th, 2023. For these subsidized loans, this law actually simplifies our DoB analysis. We don't have to worry about whether undisbursed amounts are canceled or not, because even accepted and undisbursed loan amounts aren't considered a DoB. The second sort of wrinkle for these newer CDBG-DR grants is based on another statute from 2018. A 2018 CDBG-DR appropriation included the language on this slide directing the treatment of declined SBA loans in the context of a DoB analysis. This statutory provision also has limited applicability and applies to the consideration of declined SBA loans that were provided in response to major disasters in 2014 through 2017. The law prohibits HUD and grantees from considering these declined SBA loans as a DoB. When we covered declined loans a few slides back, you'll recall that I said the declined loans aren't a DoB. So this law didn't change HUD's policy. It just codified it and prohibits consideration of these declined loans in a DoB analysis. So I know that I covered a lot. So I'll try to summarize the treatment of subsidized loans in the 2019 DoB notice and how the rules differ for CDBG-DR grants covered by the 2019 DoB notice. So to start, a subsidized loan is not a DoB if it's a short-term loan for costs that will be reimbursed with CDBG-DR funds. A subsidized loan isn't a DoB if the subsidized loan is declined or canceled. And a subsidized loan isn't a DoB if the subsidized loan is covered by the DRRA amendment to the Stafford Act for loans made in response to disasters in 2016 through 2021. This 2019 DoB notice also introduces HUD's policy on the use of CDBG-DR for reimbursement of costs paid by subsidized loans for CDBG-DR grantees with grants in response to 2016 through 2021 disasters, and it identifies the conditions that allow for repayment of these costs. So if we take a closer look at the 2019 DoB notice and how it applies to the different classes of grants it covers, we'll see some additional differences. So for 2015 disasters, these CDBG-DR grants in response to 2015 disasters aren't subject to HUD's 2013 memorandum on the consideration of declined SBA loans. On top of that, these grantees can't treat declined subsidized loans as a DoB or consider them in a DoB analysis. And this relates back to that 2018 law we covered a couple slides back. Finally, these grantees can also ignore canceled loan amounts from a DoB calculation, which was sort of the general rule, assuming the grantee maintains the right documentation. For 2016 through 2021 disasters, for this class of CDBG-DR grants, provided in response to 2016 through 2021 disasters, these grantees can treat declined and canceled loan amounts the same as 2015 grantees, and sort of the general rules we covered at the beginning of this loan section, meaning that declined and canceled loans aren't a DoB if the grantee has the documentation required by the 2019 DoB notice. These particular grantees have the added benefit of the other statutory change from 2018, that DRRA amendment to the Stafford Act. So for these grantees in particular, accepted and undispersed loan amounts received by applicants in response to 2016 through 2021 disasters aren't a DOB if the 2019 DoB notice requirements are followed and the grantee notifies the lender that it's providing assistance and the grantee enters into a written agreement with the applicant where the applicant agrees not to make any more draws on the loan without the grantee's approval. Finally, these grantees also get the benefit of HUD's policy on the use of CDBG-DR for the reimbursement of costs paid by subsidized loans if the grantee complies with conditions in the 2019 DoB notice. Reimbursement isn't, under this notice, reimbursement isn't permitted if it would cause a DoB because one of the exceptions doesn't apply, or if the use of CDBG-DR funds is prohibited by the statutory order of assistance that Dory talked about earlier, which prohibits the use of CDBG-DR funds for activities for which funds are made available by FEMA or Army Corps. The 2019 DoB notice lists a number of conditions related to reimbursement, and they include verifying all federal assistance was used towards a loss suffered as a result of a major disaster or emergency, and prioritizing disbursement of costs for LMI persons consistent with the primary objective of the Housing and Community Development Act. Those aren't the only conditions, but this slide just highlights some of the more significant conditions. So that's the end of this segment, and I think we have time for a question before I hand it off to Carrie.
Thanks, Makani. Yeah, we have one question we thought would be good for everyone to hear the answer to. It ties a little bit more directly to the first section you covered, but at large, this is the question. It says, are there any DoB requirements specific to how many times a DoB check must be conducted for a specific subrecipient or homeowner? For example, a grantee will conduct a DoB check prior to the calculation of the award. Is there a requirement to conduct another DoB check during closeout review? Or is one tiered DoB check prior to the award calculation sufficient enough?
So, a DoB check has to be done. As far as I know, HUD's guidance doesn't specify sort of the frequency with which they need to be done. But I think it's important to keep in mind that, grantees are obligated to prohibit a DoB duplication of benefits. So, a check that's done, well in advance of when an award is going to be made might create some added risk for the grantee if, there's the potential for the applicant to go and seek other assistance that might be duplicated by the CDBG-DR funds. So, a check has to be done, but I think it's, in terms of how often you want to do it, how frequently, I think it's important to keep in mind why this check is being done, right? The requirement is for the grantee to prohibit the duplication of benefits. If you're doing a check so far in advance that there's the potential that, there may be duplicative assistance that the grantee is not aware of becoming available to the applicant, then you might want to conduct one again closer to when the assistance is CDBG-DR assistance is going to be made available. These DoB notices also, require grantees to enter into repayment agreements with applicants, where applicants are basically agreeing to repay any duplicative assistance that they receive later on. So that's another sort of measure that I think grantees can take to sort of stay in compliance and avoid, a situation where they conduct a DoB check, don't identify any duplicative assistance, but duplicative assistance becomes available later.
Thanks, Makani.
Sure. Okay, so with that, I'll turn it over to you, Carrie.
Great, guys. Well, let's move on through. We're going to get even more complex and talk about CDBG-DR's match, and then we'll walk through some actual math problems. But because we've been talking for almost an hour, I want to just make sure everybody stands up and stretches, and just to get our minds in the creative mode. We have 245 people on this call. I want your best alternative to a substitute term for the acronym DoB. You can put it in the Q&A if you want. I'll kick us off. Mine is going to be dancing over bridges. No dancing over bridges today. This is prohibited. We're prohibiting DoB. So if you have any creative substitutes for the acronym, paste that in and just stand up and take a deep breath. And then we'll get going on some real stuff here while you're thinking. DoB comes up in so many different contexts, right? And match, I hate to throw a curveball by bringing up match, but so commonly when you're not talking about individual assistance, you're talking about public assistance, grantees are using their CDBG disaster recovery funds as match for public assistance program from FEMA. And so HUD worked with FEMA in 2020 to develop some guidance. We're getting a lot of questions from grantees about how to use these two sets of funds together. And we entered a memorandum of understanding with FEMA, and we agreed to develop joint implementation guidance for the use of CDBG-DR funds as the non-federal cost share for FEMA's public assistance program. So, FEMA published this as an implementation guide, and HUD published it as a CPD notice. You can find it online. But the big thing is it only applies to FEMA public assistance. So we're not talking about hazard mitigation assistance or FEMA individual assistance. FEMA individual assistance doesn't even require a match. So let's talk about what is cost share. What is match? The assistance FEMA provides through its public assistance program is based on a project cost that's calculated in a project worksheet. And you guys are the experts in this. You get the FEMA funds and you deal with them. But in that project cost, FEMA is paying a portion, typically 75%, and it's requiring the grantee to pay the remaining amount, which is typically 25%. So this amount that isn't paid by FEMA is called the non-federal cost share. Sometimes it's called local match. And as a general rule across the federal government, federal funds cannot be used to pay local match. But CDBG-DR is magic money in that it has special authority that allows payment of non-federal cost share as an eligible activity. And that authority comes from Section 105A9 of the Housing and Community Development Act of 1974. You can give me a hard time later for being a lawyer and throwing in citations, but in case you want to write it down, it's right there. You can find it, Section 105A9. So we published this joint guidance that describes a couple of different concepts. One of them is called flexible match. And the whole idea was to streamline coordination and reduce administrative costs and promote just compliant use overall of CDBG disaster recovery funds as local match for public assistance. But one of the issues that came up when we were developing this guidance was, grantees really do need to take some steps to avoid duplication of benefits and order of assistance violations when they are using CDBG-DR as match to public assistance. So order of assistance, as Dory talked about, is generally statutory for CDBG-DR. So she mentioned the general provision that CDBG-DR funds may not be used for activities that are reimbursable by or which funds have been made available by FEMA or the Army Corps. So, even when other federal assistance is being used, this concept could come up for Army Corps. I'm using FEMA as an example today. Our guidance touches on FEMA match, but I just want you to keep this concept out there and think of it for Army Corps as well. So FEMA typically operates on a reimbursement basis. HUD operates on a pay ahead basis. I say pay ahead, but you're advancing just before you have need. And because of those differences, if grantees pay too much with their CDBG-DR, they could end up with a violation of the order of assistance provision. So I win the award for the most complicated chart of the day. I really like dumping the buckets, by the way. Today we're gonna dump some buckets, and you guys are all gonna be experts in this crazy chart when we walk away. So column 1 is really dealing with, well, this whole chart is dealing with a FEMA Section 428 project. And FEMA 428 assistance is based on a cost estimate. It's actually a pilot that is a modification of just general FEMA public assistance, FEMA PA. And under the 428 pilot, the amount that is paid to grantees is based on an upfront estimate, which means, you know, if you spend less than your actual, than your estimate, then you get to keep the difference. So there's a potential benefit for grantees. If you have a cost overrun and you spend more than your estimate, there's a little bit of a risk there, right? And so in this example, the reason why we wanted to bring it up is that the grantee's particular use of those savings when the actual costs are less than estimated costs could cause order of assistance violations. So in Section 428 Alternative Procedure PA projects, there is a fixed grant amount. And so in those situations, the amount of the required match is also fixed for the most part. And that's where the trouble comes in. So as a general rule, under 428, the amount of the local match is a percentage of the estimated project cost. And so that percentage might be 10%, 25%, depending on your FEMA award. And excess funding can be used to pay for costs that are eligible uses for excess funds under the 428 alternative procedures, excess funds being the amount that's left over if your actual costs are less than the estimate. And they can be used for one of two things, either the same project or a different project. If they're used for the same project, those uses might include, for example, restoration of disaster damaged facilities and equipment, or cost-effective hazard mitigation measures, or covering future insurance premiums, or planning for future disaster response and recovery operations. And I want to look at how this plays out in this example. So let's just look at the first column. The first column is what is the estimate of the project, and that's the amount that of FEMA's obligation. FEMA obligates funds in the amount of this estimate. In this example, it's 1.15 million. That's 100% of the estimated project cost. And there are 4 sites in this particular project where the money is going to be used. The match is 25% of that estimated project cost in this example. So the match amount that the grantee has to pay, which you can see in the second to last column, is $287,500. So in this case, if you look at the second column, we've shown the estimated cost versus the cost underrun. So the actual cost is $40,000. The estimated cost for site 1 in the first gray row is $50,000, and the difference is $10,000. So when the actual cost in column 2 is less than the estimated cost in column 1, you have $10,000 extra. And that's true for every single site. There's a little bit of a cost underrun. And so the total actual project costs in this example are only $1,080,000. So there's a $70,000 difference, and this can be used for other approved work. So we wanted to give you this as a cautionary tale, because if those project costs were used for the same project. They get fed back into the same project. Ultimately, the FEMA obligation does not change, and the amount of the match will not change. And so the match is going to remain $287,500. But if as the FEMA grantee, the decision is made to move those excess funds into a different project, a different 428 project or a different PA project, then the amount of the match that's required will be less than $287,500. If the CDBG-DR funds have already been obligated, they've already been expended and committed to this project, it's hard to back it up. You've already ended up with a violation of the order of assistance because those CDBG-DR funds were used to pay for a cost that FEMA could pay for. And so the key to making sure that we comply with all CDBG-DR requirements when CDBG-DR funds will be used for match is to avoid paying for project costs in excess of the final amount of the federal cost share. The problem is, because FEMA works on a reimbursement basis, you don't know at the outset what the final amount of the non-federal cost share is going to be. And so you need some strategies so that you're not going to violate this order of assistance requirement or end up with a duplication of benefits. And so the first way to do that is to really only obligate your CDBG-DR funds to the project, or only expend your CDBG-DR funds on the project as your FEMA funds are reimbursed. So if you just are in lockstep and you're moving along and you're tracking payments with your CDBG-DR funds to your actual costs, even if you're paying ahead of the FEMA reimbursement, you're only paying as much as 25% of the actual cost as you go along. And then you will not end up with a situation where you're paying more CDBG-DR than your final non-federal cost share amount. Another strategy that I think could work well for a lot of grantees is just to hold back 10% or 20% until the very end, until you know what your ultimate FEMA final non-federal cost share is going to be. Just hold back a percentage. And this is really common, I know, for a lot of construction projects anyway. So this strategy may work for some grantees. And then if you're in a situation where you know you're going to have excess funds and you're trying to decide how to use them, before you make a decision, I'm going to use them for a different project, or I'm going to use them for the same project, it's worth talking with FEMA to identify whether there's going to be a change in the amount of the cost share. And if there is going to be a change, to make sure that you're not obligating CDBG-DR funds in excess of that final actual amount of the required local match, so that you don't end up with a finding of non-compliance on the CDBG-DR side. And so if I had one message, I would say just make sure that you are coordinating if you're using CDBG-DR as match with FEMA PA or with any Army Corps project. So, okay, now that we've had this little detour into a FEMA world, we're going to bring it back to CDBG-DR and a more basic duplication of benefits situation. We're just going to talk through case studies. This is where the math comes in. So let's start with one example, and then we'll just modify this same example a couple of times to see where we end up and throw up some different scenarios. So in the first example, we're doing a buyout. And we're talking about a fire scenario. Fires hit the town of Resilience in 2018. And the town of Resilience says, I'm going to create a buyout program. And that way I'll reduce mudslide risk in that disaster risk reduction area that I've identified after my fire. And so the town is developing its policies and procedures, and it identifies pre-disaster value across the board for buyouts as part of this buyout program post-fire. Jane lives in this buyout target area, and before the buyout offer, she received $30,000 from FEMA IHP to rehab her home. And she's expended $20,000 of that $30,000 on her rehab. She also got a $60,000 SBA loan for rehabilitation, and she expended all $60,000 on rehab. So a couple of questions come up right over the bat. You know, what do you do when you've gotten rehabilitation funds and they've been expended and some have not been expended, and now you want to do a buyout? The pre-storm value in this case is $140,000, and the current fair market value is $115,000. In this case, the town is using the pre-storm value for buyouts. So let's walk through what we have here. Total need in this case is the pre-storm value because that is going to be the acquisition cost, and the total assistance is $30,000. Why $30,000 and not $60,000? Because this is a DRRA disaster. It's in that window from 2016 to 2021. And we know, based on what we learned in our facts, that all of the federal disaster assistance was expended for a disaster loss, or will be if we collect this the leftover $10,000 from FEMA. Okay, so we have total assistance here of $30,000, and we have non-duplicative assistance, $30,000 for FEMA funds that are funds for a different purpose that are rehabilitation. But we have a question mark, right? Because what to do about this $10,000 that have not been expended? And so in this case, we think we might have a total assistance amount of $0, but we've got some problems that we need to work out. And so we have a preliminary maximum award here of $140,000. So let's review where we are. You know, we've got a necessary and reasonable cost principles issue. We've got, you know, because we don't want a windfall. We don't want Jane to be able to put $10,000 in her pocket. And as Dory pointed out, the necessary and reasonable cost principles in Part 200 sort of overlay with duplication of benefits. They're not exactly the same, but they're really closely related. So the takeaway from both of those is we don't want windfalls. And then we also want to make sure that costs are properly expended, right? So FEMA spent 20 of the 30,000 from FEMA on the rehabilitation, but that rehabilitation doesn't need to be finished because of the buyout. So going back to what's reasonable, it's not really reasonable to just wrap up that FEMA rehab money and expend those funds for FEMA rehab if the house is just going to be torn down anyway. And it's not really reasonable for Jane to just put cash in her pocket that when FEMA's providing it for rehab. So what are our options? You know, there's an option to require Jane to return those $10,000 to FEMA, or reduce the amount of Jane's buyout by $10,000. And kind of which option that you take here needs to be informed by, you know, whether that loan is going to be a duplication of benefits. And so under the DRRA, you know, a loan is not a duplication of benefits only if all federal assistance is expended for a disaster-related loss. So they have to keep that in mind to you know, when they're moving forward. And also, you know, looking at the purpose of those SBA funds. In this case, they were expended for rehabilitation. And so you could say, well, they're excluded from that calculation. And there just end up with the, you know, there are questions here, and you have to be able to consider what is the impact of either of these choices. So there's also the question of how to treat the grantee's requirement that is in all Federal Register notices for buyout programs, that if you're going to pay pre-disaster value, you have to pay it universally across your program. And so you kind of also have to consider the effect of, well, if I reduce the amount of Jane's buyout by 10,000, am I complying with that requirement? So lots of questions. At the end of the day, the notice requires that the initial acquisition price, the total need, is the same for all of your participants in your buyout program, but it doesn't prohibit reductions for duplication of benefits and necessary and reasonable cost principles. So for this scenario, it's okay to start with your pre-storm value and then back out whatever you need to make sure that you're complying with DoB and necessary and reasonable requirements. Then let's look at total assistance. You know, for SBA, all the loan funds were expended for a disaster-related loss, and the FEMA, those 20,000 in FEMA funds were expended for a different federal purpose, that is repair in the case of FEMA. And so in this case, if you decide you're going to go ahead and give that 10,000 back to FEMA, that's one option. Or you can reduce the amount that is, if they're not going to return it to FEMA, just reduce it off of the maximum award for the 130,000. And then you have complied with your duplication of benefits requirements, and you've complied with your necessary and reasonable requirements, and you have still provided an amount to this individual that is in excess of their fair market value, which for this example was 115,000. So let's complicate it a little bit. Let's say we're going to reduce the final acquisition price by the amount of the unexpended FEMA rehab assistance. And what if when we did that, it caused the buyout acquisition price to drop below fair market value? So we're gonna, in order to get to this example and consider it thoroughly, we're gonna change the amount of unexpended FEMA assistance to that full 30,000 that she got up front. So in this case, we've got a pre-storm value of 140,000. Again, this is preliminary because we're just figuring it out. The total assistance is the 30,000, and it doesn't include SBA here because the SBA funds were expended for the purpose for which they were required, and they were expended for the repair. And then we can exclude non-duplicative items. The FEMA funds here they're funds for a different purpose, but you can't have $30,000 cash on hand. If we reduce the price to 110,000, taking the same approach that we did for the first example, then you're going to end up with a price that is below fair market value because the pre-storm value is 140,000. Is that really fair to Jane to pay her less than her house is actually worth? And at the end of the day, it's probably reasonable to just pay Jane fair market value for her home. The grantee is receiving something for value in this case, but the grantee might want to take some extra precautions to demonstrate reasonability. They might want to prepare a memo and just put it in their file to document why they concluded that fair market value was reasonable. And at the end of the day, necessary and reasonable is a call that the grantee has to make. It's, what is necessary and reasonable has some meets and bounds around it in Part 200, but it's not so defined that it takes out all judgment calls. So the best way that a grantee can address this problem is by documenting why they conclude something is reasonable. And then, you know, if the seller, there might be a number of examples that could come up, and you just pull from different facts. The seller could reject a lower price. You know, the grantee might just conclude, you know, we obtained something and we're paying fair market value for it. Or the grantee might conclude that FEMA is the one responsible for collecting unused FEMA assistance in this case, and it would probably be a good idea, if that were the tact you were going to take, to notify FEMA that those funds were not used and that you've bought out the house. So let's modify this example one more time. What if Jane spent all the FEMA funds, but only expended the initial disbursement amount of the SBA loan proceeds, the $25,000, and the remaining SBA loan proceeds haven't been dispersed yet? So in this analysis, same $140,000, and the total assistance is, you know, we've got a DRRA disaster. $25,000 of the SBA was used for disaster loss. The other SBA funds are not dispersed yet. So we've got $30,000 in FEMA funds that are funds for a different purpose. We're assuming for purposes of this example that they were expended on the rehab. And so because they were expended on the rehab, and because all of the amounts that were dispersed by SBA were used for a disaster loss, the other SBA is not dispersed, then you have a situation where you can cancel the SBA loan. You can make sure that you're determining that that it's not available. You can rely on some of those other exceptions. You've got a little bit of flexibility here in how to approach. So when you're calculating that maximum award, you know, consider that necessary and reasonable analysis. Is there anything here that is going to be a problem even if the funds were dispersed later? Probably not, because they have to be repaid, but there might still be a duplication of benefits question. So those are the questions that you might ask when you're just viewing this for the first time. So at the end of the day, the best approach in this case is to go ahead and cancel that amount of the SBA loan that's not dispersed. If you do that, then all federal assistance amounts will have been expended. The amount of the SBA loan and the amount of the FEMA funds will be used for a different purpose, repair, and there would be no windfall because the remaining amount is canceled and therefore not available, and not a duplication of benefits. Let's go to a multiple disasters example, and I'm going to move through this pretty quickly. So in this case, a flood strikes the state of bad luck in 2017, and then it's flooded again by a massive storm in 2019. Sally has a home that was affected by both floods, and she gets $20,000 after the first to rehab her home. And then she gets an additional $20,000 after the second flood, and she has not completed any rehab since the 2017 flood. So she sought assistance from CDBGDR, and the remaining rehab is going to cost $100,000. So what do we do with this? You know, we've got her assistance. She got $20,000, and again $20,000 in 2017 and 2019, and it's going to take $100,000 to deal with her home. So the big point that I want to make here with this example is, you know, what documentation does Sally have to have for original rehab after the 2017 flood? You know, if she doesn't have any documentation, how long does FEMA require her to maintain documentation? And if the period FEMA required Sally to maintain documentation is passed, does Sally know how much she expended? And so the point that we want to make here is that we provided some flexibility in the 2019 DoB notice that recognizes that, you know, in particular, FEMA's retention period for its disaster assistance funds might be shorter than the time period that passes between the two disasters, or the time period between the first disaster and the FEMA assistance award and the application for CDBG-DR after the second disaster. And so if there is that time period has passed, then we have some flexibility under the DoB notice to allow for a self-certification if that record keeping period has passed. So let's say Sally signs a self-certification. She expended 15,000 of those 20,000 in FEMA funds, and there's no evidence of fraud, and FEMA's documentation period has passed. Then it's okay to say, okay, we've got 100,000 in need. We had total assistance of 40,000, but when you exclude those non-duplicative items, Sally certified that she used 15,000 for the same purpose. And so you can exclude the 15,000 from the 40,000 in total assistance to get a DoB of 25,000, and you have a maximum award of 75,000. But when you do, make sure that you know with these two disasters that Sally obtained and maintained flood insurance, because you don't want to get bitten by the one bite rule after a flood disaster. So what if FEMA's documentation period has not passed? Well, then it's a little bit more complicated, right? Sally doesn't have documentation. And if you want to actually try and corroborate any amount that she says that she has expended, then you can do that if you have reasonable estimates that the work was recently done. And that's going to take an inspector coming out to the house, and it's going to be more time intensive. So you can do that as a grantee, but you're going to end up with a little bit more time intensive process. And then what if the state has no evidence that Sally used FEMA funds? Well, you know, if you really have no evidence that Sally used those funds, then the rehab assistance is for the same purpose, and the funds not expended for rehab are a duplication of benefits. And that's just complicated, and sometimes the reality is you have to treat things as a duplication of benefits. So let's say that happens. What are your strategies? There are a couple of strategies for facing a DoB. One is, does Sally have cash on hand? And if so, you know, the easiest is for her to pay it into an escrow or bring it to closing when you're working on the rehab assistance, and you might be able to delay a closing to allow her to get those funds. You also might be able to reduce the scope of the rehabilitation if you can do that and still make decent, safe, and sanitary housing that's going to be able to qualify you for a certificate of occupancy. You can talk with FEMA to see if it would revise its award for the 2017 disaster to allow some of those funds to be used for other needs assistance. FEMA will not always do that, and that's also a labor-intensive process. You can also double check to make sure if, you know, the FEMA may, you know, she may have used some of her FEMA assistance for interim housing, and it's possible that the FEMA award allowed for that. So look for that FEMA award letter. And then if all else fails, consider a buyout. And if a DoB is found after funds are awarded, then, you know, you've got to actually take steps to identify the DoB. You can reevaluate need. You can check the documentation in the file, but ultimately you're probably going to have to follow your recapture procedures and request repayment. And so when you have to deal with a recapture, it's difficult if you haven't put your procedures in place, your policies and procedures to make sure that you know what steps you have to follow, and to make sure that you can enforce the subrogation agreement that you required all of your grantees to sign, your applicants to sign when they receive a CDBG award. And you may have discretion to determine the method and timeframes for recapture, but a grantee that doesn't recapture is liable to HUD for non-compliance. So keep in mind your best practices to avoid a DOB, and most importantly, make sure you save receipts and promote use of all assistance for the purposes that it is provided, even before your application period starts. Get out there with messaging. You can also design programs that are hopefully going to avoid a DOB, but you can't always do that. So Olivia's going to talk about some resources, but are there any questions? Real quickly, we might have time for one.
Yeah, Carrie, I would like to bring us back, if you don't mind, to slide 46, and we're going to use the first example you had with Jane to just have a follow-up question to look at it slightly different. So at large, I guess the question is, what if Jane, and it kind of ties to this slide and the slide after, but what if Jane used the 10K for another reasonable disaster expense other than the rehab, such as a vehicle replacement, temporary housing, or food? How would this equation and analysis pan out differently?
Yeah, this goes to the heart of what FEMA allows its funds to be used for, right? So sometimes individuals have legitimate disaster-related needs, and they've expended those funds for legitimate disaster-related needs, like car replacement. But if FEMA doesn't allow the use of those funds for the other use, then they are funds for the same purpose, and you have to treat them as funds for the same purpose. So let's say the 20,000 was expended for or the remaining 10,000 was expended for something that was not what FEMA allowed. It's your question is more a necessary and reasonable question, and a duplication of benefits question. It's a different purpose than the buyout. So it's not a duplication of benefits for the buyout, even though it would be for rehabilitation. The real question is, okay, there's no windfall, but what do you do? In that case, if I were the grantee, I might make a reasonability memo when we're talking about cash in pocket that addresses, you really need to think about the risk analysis here. You can either reduce the amount, or you could notify FEMA that, you don't have documentation that that amount was expended for repair, but it's not a duplication because it's not, you're doing a buyout and you're not doing a rehab. And so you're not going to do anything to collect, or you can just say that's FEMA's responsibility. And I think that's, in all of those cases, there's some risk to the grantee. Probably if I were in this scenario, I might call my CPD representative and see if I could get some assistance or just some collaboration. And the other opportunity here is to just collaborate with FEMA.
Thanks, Carrie. I reposted in our chat the previously mentioned DoB session that has a more basic overview, as today's session went into greater detail. And it's one of the resources that you'd be able to locate on the HUD Exchange. And this material, the recording and the transcripts, will be posted on the HUD Exchange as well after today's session in the coming weeks. And the materials are already posted there, so you're able to access all of the slides we just went through and the great details and examples and case studies that we just showcased. Another resource that I would like to highlight very quickly is this Disaster Recovery Tools and Templates library. It's available for both CDBG-DR and CDBG-MIT grantees and showcases the full life cycle of your programming, as well as some other examples that you have hyperlinks to. If you have any additional questions outside of today's session related to DoB, feel free to utilize Whova and find the session board for today's topic, and we'll be able to continue answering those material. And the information to join these sessions or to join Whova is located on the screen. And this is the end of our current session. We have 4 additional sessions coming up today in our clinic design. So you're able to choose which sessions you want to attend to. So we have the procurement and vendor management session, environmental review and heroes and best practices for disaster recovery grantees coming up at 3:30. And then later this evening at 5 o'clock, we have the resources for managing and monitoring subrecipient session, as well as CDBG-DR financial management from certification to launch. Thank you so much for joining our session today. You're able to take the next 30 minutes to regroup for our next session. And I really want to thank Carrie, Dory, and Makani for the expertise that you were able to give today and the guidance that an overview that you provided for our grantees. We really greatly appreciate it. You guys have reached the end of the session. You're more than welcome to log off. Thank you.